Yes.
With the consent of the respondent, I beg to mention item number 7, my lord. That will be taken on 19th, my lord.
On the request of Mr. S. Bora, learned counsel for the petitioner made with the consent of the opposite party, this matter stands adjourned. First up, registry to list as prayed for by Mr. Bora, registry to list this case
On
again 19/9/2024.
Lordship, I beg to mention item number 6. We had filed one rejoinder affidavit counter to the ONGC, Your Lordship. Yesterday we haven't filed. I have consent to the ONGC department also. On Tuesday, if Lordship permit.
Mr. B.N. Gogoi, learned counsel for the every matter cannot be fixed like this.
I beg to mention.
Mr. B.N. Gogoi, learned counsel for the petitioner submits that a rejoinder affidavit in response to the counter affidavit filed by the ONGC authority has been filed on behalf of his client only yesterday, but the same is not on record. Full stop. On the request of Mr. Gogoi, let this matter be listed again after 2 weeks by tagging the rejoinder affidavit in the record of this.
I am deeply honored.
May I please, Your Lordship? Lordship, with the consent of the other side, I beg to mention item number 4 and 5 of the daily list, Lordship. In this matter, Lordship, during the pendency of the case, Lordship, petitioner was dismissed from service, Lordship, followed by a departmental proceeding, Lordship, which is under challenge, Lordship, and that dismissal matter, Lordship, is fixed on Tuesday, Lordship. Lordship, can it be taken up on Tuesday, Lordship? If I will succeed in this matter, Lordship, then it will survive. Otherwise, Lordship,
No, no, it is after a week.
Lordship,
The prayer of-
item number 10.
Wait, let me pass the order 4 and 5. You are in a hurry,
No,
going somewhere.
no, no.
Then please wait for 2 minutes. Mr.
N.K. Sharma, Lordship.
N.K. Sharma, learned counsel appearing for the writ petitioners, submits that a connected matter. No, submits that another matter which would have a bearing in these writ petitions is fixed before this court on 17/9/2024 and is likely to be finally heard and disposed of by the court. As such, these matters be listed again after 10 days, awaiting the outcome of the said proceeding. In view of the prayer made by the learned counsel for the petitioner, let these matters be listed again after 2 weeks. Yes,
Lordship, item number 10.
yes.
In this case, the petitioner has faced 2 criminal trial, where he was acquitted. These documents are vital. We need to bring those documents.
On the prayer of Mr. B.K. Bhagwati, learned counsel for the petitioner, this matter stands adjourned for 3 weeks so as to enable him to file an additional affidavit bringing certain subsequent developments in the record of this case.
Lordship.
May please, matter may come for order, my lord. That but the retirement benefit, my lord, after motion, my lord, it's not been listed, my lord, off listed. That's why on motion on 1st of April.
1st of April.
April, 4th of April, motion was issued, my lord. Thereafter, my lord, it's off listed. That's why.
Next week.
Lordship, I beg to mention item 8 of today's daily list, Lordship.
Hmm.
I appear on behalf of Mr. H.K. Das, Lordship. In this matter, we lost contact with the clients, Lordship, but recently we have been instructed to file a rejoinder, Lordship. So kindly 2 weeks may be granted to bring on record those facts.
Mr. A. Chetri, learned counsel appearing for the writ petitioner, submits that due to lack of contact with the petitioners, necessary steps for filing rejoinder affidavit could not be initiated in this case. As such, the learned counsel has prayed for adjournment of hearing of these matters. First, upon the prayer of Mr. Chetri, hearing of these matters stand adjourned. List this case again after the ensuing puja vacation.
Lordship, I am MP Sharma, Lordship.
Sorry, MP Sharma. Sorry, yes.
Obliged.
You are not. Your name is not appearing. In
I
this.
appear on behalf of Mr. H.K. Das, Lordship.
Okay.
Obliged, Lordship.
I beg to mention for withdrawal, my lord. I want 2 more win.
May it please your Lordship. Lordship, I am praying for listing of one IA, Lordship, in a writ petition, Lordship. Can it be on any date in the next week, Lordship?
What is the IA?
IA, in this IA, we have been praying for an amendment of the writ petition, Lordship.
Next week.
Deeply.
May I please your lordship, listing for withdrawal lordship.
When?
Lordship, Monday, 16th. Oblige.
May I please, your lordship, I want to mention regarding listing of two matters next week
Hmm.
for admission on Monday or Wednesday.
What is the urgency?
Urgency, it's for pensionary benefit, lordship, for defense personnel.
You don't know. You're not sure.
No.
Mention is only for urgent matters. You find out what is the urgency and come tomorrow, we'll consider.
Daily list for admission, I can want.
Yes.
My lord, question of maintainability,
Yes.
maintainability lordship.
Devubrata Tiwari, Lord.
Raised by the learned trade lordship.
Can
The
you- one of you please
2006,
Yes.
2006 applied on 2006. After that, Lordship, 2020 a representation was filed before the ADC, Lordship. Now it is, Lordship, almost 20 years, Lordship.
Where is the judgment of Supreme Court?
Yes, Lordship. Assess.
Mr. Ahmed, let the agony end for your client and for you also, and
Lordship,
for all of us, huh?
that is a
Yes. This has become a nuisance, this business of compassionate appointment. 2005, 2006,
delay.
obviously there will be no appointment. Which paragraph relevant?
Lordship, it is paragraph 30, Lordship. Mhm. 30. Lordship, just.
Not paragraph 30. You
Lordship.
also don't read, huh? Just two
Lordship.
papers to the court. 35.
Yes, Lordship, 35, Lordship.
What
I'm
are you
sorry.
saying 30?
So, sorry, Lordship, 35.
Take down, heard Mr. M. H. Ahmed, learned counsel for the writ petitioner, also heard Mr. J. K. Goswami, learned additional senior government advocate Assam appearing for the
One and, his Lordship.
referral numbers.
Yes, Lordship, one and.
So we are
Lordship,
making an
yes,
arrangement
what-
to,
No,
you
Lordship.
don't even know who you are representing.
No, Lordship, Lordship, I'm on behalf of Lordship, it is 5, Lordship. 5 and 6.
You are for? Mr. R. Dhar learned SCPW for 1 to 4 and Mr. J. K. Goswami learned additional senior government advocate Assam for response numbers 5 and 6. Full stop. The case of the writ petitioner in brief is that her husband died in harness. Her husband, who was serving as a grade 4 employee under the establishment of executive engineer, PWD, Botadrova, Dhing, and Roha Territorial Road Division, Nagaon, died in harness on 21/10/2006. First of, having lost the sole breadwinner of the family, the petitioner claims to have submitted an application on 14/11/2006 seeking appointment on compassionate ground as a scheme framed by the government of Assam, providing for such employment so as to give immediate relief to the family members of the deceased, was in vogue at that point of time. Full stop. However, since no action was taken on the said application, the petitioner had submitted a representation dated 16/11/2020 to consider her case for compassionate appointment. Full stop. The matter was thereafter placed before the meeting of the district level committee bracket DLC, Nagaon. However, till date, no decision has been taken in the matter. Hence, this writ petition. Full stop. By relying upon the decision of the Supreme Court in the case of State of West Bengal versus Devabrata Tiwari and others, reported in 2023 SCC Online SC 219, the learned departmental council has submitted that this is evidently a case of prolonged delay. Stop. After the lapse of nearly 18 years, the question of considering the application submitted by the petitioner for compassionate appointment cannot be considered in her favor at this point of time. First of all, after going through the materials on record, next para, I find that although the petitioner had submitted the application seeking compassionate appointment on 14/11/2006, yet since then, there is no document available on record to show that she was pursuing her claim until 16/12/2020, when a representation was submitted by her for the first time, pursuing the application for compassionate appointment. First up. Over the period of 14 years, nearly 14 years, the petitioner has remained silent and therefore slept over her right, if any, to be considered for appointment on compassionate ground. Next para. It is trite law that the scheme framed by the government of Assam providing appointment on compassionate ground to the family member of a deceased government employee who dies in harness is aimed at providing immediate relief to the family which had lost the sole bread earner. Such a scheme does not guarantee employment as a matter of right. Moreover, the scheme framed by the government of Assam has also been withdrawn way back in the year 2017. In the case of Devabrata Tiwari, the Supreme Court, while dealing with the aforesaid aspect of the matter, has clearly observed that due to prolonged delay in pursuing the application of compassionate appointment, since the immediacy is diluted or lost in the matter, hence diluted and lost, and the financial circumstances of the family of the deceased might also be changed. It will not be proper to grant compassionate appointment in such cases by considering it as a matter of inheritance based on a line of succession which is contrary to the Constitution. First off. Having regard to the facts and circumstances of the case and the prolonged delay in pursuing the application for compassionate appointment, this court is of the opinion that there is no scope for granting any relief to the petitioner in the present case. As such, this writ petition stands dismissed.
If you lordship permit lordship to my lord point out my lord two documents lordship. My lord, my page 30 lordship that was representation was my lord in 2011.
Yeah.
My lord.
Having regard to the facts and circumstances of the case, even if it is shown that the
Communication.
petitioner had made some efforts to pursue her claim. No appointment on compassionate ground can be made on this day, that is nearly after 18 years since the death of her husband. More so, since the scheme for appointment of on compassionate ground itself has been discontinued by the government. Under the circumstances, this court is of the opinion that there is no merit in this writ petition. The same is according to this.
Lordship.
There is some adjournment request. In item 3.
Lordship, may I say? Lordship, in terms of your Lordship last order, I received instruction, but somehow I overlooked the direction that an affidavit was directed to be filed, Lordship. So yesterday evening, when I saw the order, I immediately prepared the affidavit. I have sent it for signing also. If Lordship permits, then Lordship may allow me 1 week time to file the affidavit, or Lordship may proceed with the available instruction also.
You are appearing.
I'm appearing for some of the private.
No, you file the affidavit, we'll take it after vacation. Before vacation, it will not be possible.
I apologize, Lordship. I apologize. I overlooked the order, Lordship. Somehow.
All right. Heard learned counsel appearing for the contesting parties who are present. Mr. Nayak submits that in terms of the Mr. P. Nayak, learned standing counsel,
Finance.
Finance Department, Assam, submits that in terms of the order dated 23/7/2024, he had obtained instructions for filing an affidavit, but due to oversight, the affidavit could not be filed. Full stop. Tendering apology to the court for such lapses on the part of the department, Mr. Nayak prays for 2 weeks' time to place the affidavit on record. Full stop. Considering the purpose for which the affidavit was called for by the order dated 23/7/2024 and the crucial role the same is likely to have in the outcome of this proceeding, this court is inclined to grant 2 weeks' time as a last opportunity to the departmental authority to file the affidavit. Full stop. As such, it is provided that within 27th of September, the affidavit on behalf of the department shall be brought on record. Before vacation, I don't think it will be possible to hear the matter. Mr. Chaudhary?
This is a slightly complicated service matter,
Yes.
so.
Thereafter,
It may be fixed,
the-
then.
by serving a copy of the affidavit on all the respondents, on all the copy of the affidavit, by serving copy upon the learned counsel for all the interested parties. Response, if any, to such affidavit be also brought on record within a period of 10 days thereafter. Register to release this matter for hearing again in the first week of November 2024 as a fixed item. These matters to total patients. First week of November.
What should we fix a date? That will make it because of my frequent travels. If your lordship.
Then I'll release it from Parthad and fix a date because I'm not sure.
Anyway, on in first week of November, just a date maybe 5th of November or 7th of November.
5th of November.
Item 9.
Yes. Yes, what is this? matter?
Lordship, the petitioner is challenging an impugned order dated 19/9/24 day, whereby a penalty of rupees 1,84,000 odd rupees was imposed upon the petitioner. Lordship, the petitioner is challenging this imposition of penalty on the basis that the whole proceeding was not held according to procedure established by law. As well as
Where
my
is
lord,
the order? Which page?
Lordship, 49 and 50. 49 and 50 of the writ petition.
So any disciplinary proceeding has been initiated.
Lordship,
What has happened?
Lordship,
in-
court of inquiry proceedings were held.
Hmm.
Lordship will file the first order of convening court of inquiry at page 23.
What has happened in that?
Lordship, the first court of inquiry were found with procedural irregularities, and the commandant, the CE project again directed that fresh proceedings be held.
Hmm.
And Lordship, in the fresh proceedings, the written statement, the reply given by the petitioner is not considered at all. Lordship, moreover, the evidence adduced by the petitioner was not considered. Moreover, the suggestions given by the CE project in the earlier communication, whereby the earlier court of inquiry proceedings were found laced with procedural irregularities. Lordship, those suggestions were also not considered. Moreover, if Lordship looks at the communication, there Lordship, the CE project also suggested that there was another person who was alleged to have facilitated the petitioner to commit the irregularities of misappropriation. Lordship, however, the comments of those for that person was not taken. Lordship, recently it has been found that that person did not commit any omission, did not commit the error. However, it was only error of omission, and that Lordship, the charges against that person has now been Lordship abolished.
That
What?
person is another person.
Another person, Lordship.
What about the petitioner?
The petitioner it was said that Lordship, that person facilitated the petitioner. He made the errors in the documentation, and based on that, the petitioner misappropriated kerosene oil and etc. However, Lordship,
So, but whether misappropriation was proved?
no, Lordship. According to the petitioner, the misappropriation was not proved, and finally, it has been found that there was no misappropriation of kerosene oil at all. So that proved.
Found by whom?
The authorities, my lord. My lord will look at our affidavit in reply.
Lordship, may I submit? Lordship,
At
can it
page
be taken
159.
after some time, Lordship?
Why?
My senior is on the way, Lordship. Just
Let her come. Who is your senior?
Mr. SP Chaudhary, Lordship.
Let us see if he
Lordship,
comes,
at page
then we'll-
one.
otherwise you argue.
Lordship, at 129 of our affidavit in reply. 129 of our affidavit in reply, Lord.
$129.
Para 3 and 4. Detailed scrutiny of court of inquiry proceedings reveals that Ellis manipulation tampering of convenor was prepared based on the indent passed for SK oil in the month of November 2011 by GS Wenso Roshan Kumar. SK oil in the Ellis manipulation tempered convenor was duly endorsed in the daily balance sheet by the individual. Cutting off date on the Ellis manipulation does not have any financial bearing, and it seems to be error of omission rather than error of commission. Further, the court established that physical move of SK oil could not be ascertained at the belated stage due to non-availability of sufficient related documents from the unit. However, GS Roshan Kumar produced the extract of gate pass register, which reflects the move of vehicle on 30th November 2011 with SKOL having entry at serial number 258 in the register maintained at the gate. The court has also opined that the physical move of SKOL after receiving the quantity of convey note is the responsibility of the receiving authority. In the light of the opinion recommendation of the Court of Inquiry proceedings, I am of the view and recommend that the impugned case be set aside and vigilance clearance be given to Roshan Kumar. Being a vintage case, an elite charge could be only an error of commission, as there has been no financial bearing as well. Lordship, now the imposition of 1,84,000. Lordship, the original amount was 1,50 something thousand. Then after addition
So
of tax,
Roshan Kumar was given a clean sheet.
and moreover, it was said that there was no misappropriation of kerosene oil.
No, but what about the inquiry, court of inquiry about against your client?
Exactly, Lordship. The Lordship will come to the memorandum at.
I will not go anywhere. First, tell me what happened to the court of inquiry against your client.
Lordship,
Why can't you tell me?
Yes, I was found guilty, Lordship.
Hmm.
Then one imposition of 1,84,000 rupees was imposed upon me. And Lordship, the price breakup is given at page 65 of the petition by the authorities themselves. If Lordship looks at that, then out of the 1,84,000, majority of the amount was for kerosene oil, my lord.
So have you challenged that order?
Yes, Lordship. We have challenged the order.
Challenge where?
Lordship, we have challenged the impugned communication whereby we were informed about this memorandum, and at the time of filing this petition,
Challenged where?
memorandum was not served upon us, my lord.
Challenged where? Where did you challenge it?
Lordship, we
Before
prepared
the
an
deputy commissioner.
we prepared an appeal also, Lordship.
Where?
Lordship will find it at page 40 of the petition.
All right, after vacation. You are not answering the question. I am asking you, where did you challenge it?
Before the Lordship, actually the appellate authority passed this order. He was not the disciplinary authority.
Where did you challenge this finding?
Lordship, before the Director General Border Roads.
Mr.
Before the Director General.
Where is it? Where is it?
At page 40, Lordship. Of the petition.
Page 40. All right, then what happened?
Lordship, Director General is the board appellate authority, but again, this order of imposition of penalty was again passed by this appellate authority itself.
Where is that?
Lordship, the order is at page 49 and 50. Lordship already went through.
No. In that order, it was mentioned that So is it the same transaction?
Lordship, same transaction.
Same transaction.
Same transaction. Again, my Lordship, after imposition of this penalty, again they had again served us with a communication dated 18/12, whereby they had informed that proceedings under Rule 14 of CCS Act will again be held upon the petitioner on the same alleged facts and alleged misappropriation, Lordship. But however, he has already been imposed penalty. And if Lordship looks at the penalty, it's 1,84,000. Originally, it was 1,54,000. After imposition of tax, it becomes 1,54,000. And out of the 1,54,000, 1,29,000 was only for kerosene oil, which now has, my lord, come out that there was no misappropriation.
So what is your submission?
So my submission is that, Lordship, the imposition of penalty for kerosene oil is now gone, since it has been found that there was no misappropriation of kerosene oil. Because, Lordship, in the allegation which was given, Lordship will look at page 49, point number C.
Yes.
Lordship, this imposition of penalty upon the petitioner, and at point number C, Lordship will also find Roshan Kumar's name, the one who has now been given a clean sheet. So Roshan Kumar, he tempered the official notes which facilitated the petitioner to misappropriate kerosene oil. But now it has been found that the Naresh Kumar did not facilitate it was only error of omission, and now there is no misappropriation of kerosene oil. So out of that 1,84,000, my lord, most of the amount was for kerosene oil.
And the amount has been recovered.
It has been found that there was no
No,
misappropriation.
no,
at
has
all.
it already been recovered from your client?
Not my lord. It has not been recovered
There's a
because
stay
there was a
order.
stay order. Due to the stay order, it has not been recovered. Moreover, my lord, again, starting of proceedings under Rule 14 upon the same set of allegations after imposition of penalty, we have also challenged.
Fresh set of proceeding.
Lordship will find it at page 37 of the litigation.
Yes.
It is intimated that Court of Inquiry is ordered to investigate the circumstances under which misappropriation of government stores by the above named individual. The Court of Inquiry has been finalized under DGPR Fight so and so. As per the orders of DGPR, disciplinary action in respect of the above named individual presently on postage range to be initiated under Rule 14. Memorandum under Rule 14 being served to the individual shortly. Till that time of filing of the requisition, my lord, it was not served. As regards call upon for pay of 1,84,907, Naresh Kumar Upadhyay to recover the good loss. There is some language problem. In the view of the above, it is requested to instruct individual concerned to deposit the EBIT amount into government treasury and forward a copy of TR to this headquarters. And Lordship will find the memorandum at page 64 of the resolution. It came along with this communication. So Lordship, in say page 65, Lordship will find the amount breakup. Towards the last. And Lordship, originally the Court of Inquiry was started for alleged misappropriation of 1,260X. But however, Lordship, the amount breakup doesn't contain anything regarding the X. And thereafter, the Court of Inquiry terms of reference were amended. Then this kerosene oil, rice, sugar, etc. were included later.
Who had passed the order dated 19/9/2014? Who had issued it?
The Director General Border Roads, Lordship.
And you preferred an appeal before him?
Lordship, because Lordship, he was the appellate authority, Lordship. The disciplinary authority is the CE project for the petition.
All right. So you place when was the initial court of inquiry was initiated on 12
Page
January
20
2012.
Lordship. The
What is the
Lordship,
date?
for 2nd January 2012, it's in page 23 of the writ petition, Lordship. And Lordship, it was issued by the respondent number 4. Again, he is not the disciplinary authority. Thereafter, the terms of reference of that court of inquiry were amended. Lordship will find the amended one at page 24.
Page?
24. After amendment, all these kerosene oil, rice, etc. were included. Earlier, the inquiry was only for X. Then Lordship, that inquiry was found pointed out, the CE project pointed out several procedural infirmities. And again, the inquiry was reheld by FRES. My lord will find the communication at page 25, where it was pointed out that there are several procedural infirmities.
So where is the report of the court of inquiry? What happened then? This court of inquiry ended where? Where is the order?
Lordship. Lordship 37, page 37, Lordship. Details are there in page 38 and 39.
No, this is the action proposed on the court of inquiry report. Where is the report of the court of inquiry?
The report was not handed over to us at the time of filing of this petition.
Yes, where is the report? Where is the record?
Lordship, I don't have the brief with me presently. It is with my senior lordship. It may be kept as part heard lordship.
No, we'll pass the order now. We'll mark his
Yes, sir.
absence and allow the repetition. Yes, then what happened? No copy was given.
Lordship, no copy was given. Thereafter, Lordship, the second court of inquiry, Lordship, after the CE project pointed out several flaws in it, Lordship, we were given
Where is
petitioner.
your senior? Where is it?
He informed me over phone that he is coming, lordship,
He's coming from where?
from his home, lordship.
Why it is 11:30 now? No, we are not concerned whether he come or not. The court cannot be asked to wait.
Lordship, regarding the misappropriation of kerosene oil, it was alleged that the misappropriation happened, transaction happened only on papers. The real move of kerosene oil was not there.
Let us go through the papers one by one now.
Lordship,
What is there in page 38?
Lordship, page 38 is our representation, Lordship. Lordship, the impugned order at page 49 and 50, it, Lordship, gives the conclusion regarding the court of inquiry. At 49, Lordship, the impugned order. Lordship, already paid. And regarding the rest of the items, Lordship, which consists the minimal part of the imposed amount, Lordship, we had already given the clearance certificate issued by the officer commanding, as well as the stock verification certificate, which were both issued to us. Lordship will find it at page 33, as well as 35. It shows that there was no deficiency of stores, Lordship, when the petitioner is in charge of the store. However, Lordship, these evidences were
Court
not-
of inquiry was held against Roshan Kumar also.
Roshan Kumar also, Lordship. And it was, the whole thing was that the misappropriation of kerosene oil, which was the major misappropriation, it was facilitated by Roshan Kumar. He committed the error on papers and no physical move of kerosene oil was there. But since it was mistakenly put up in the paper, and they said that the misappropriation was only on papers. But however, now it has been found that there was no misappropriation and it was only error of omission, not error of commission.
And where is the fresh inquiry you said, page number? Disciplinary proceeding now?
Lordship, we are given one petition questionnaire. We have, Lordship, annexed the questionnaire at page.
No, there is a memorandum of charge.
Lordship, memorandum is at page 64 and 64 to 66, Lordship, of the petition. It proposes to again initiate inquiry, Lordship, and proceedings under Rule 14, Lordship, upon the same set of allegations.
That is 64. There is no page 64. It starts.
Writ petition, Lordship. Writ petition 64. Where's the last?
So conclude your argument.
So, Lordship, the whole imposition of penalty, which was, Lordship, imposed upon the petition.
Where is the document to show that the omission of Naresh Kumar, Roshan Lal, or whatever his name is, Roshan Kumar, had led to this discrepancy? Where is that document?
Lordship, it's mentioned at page 49 and 50.
Page 49.
That's
Yes, which paragraph?
C, Lordship, paragraph 3.c. Display action again under Rule 14 of CC be initiated against Sri Roshan Kumar for manipulation, tampering with official records, convenant, which facilitated serial store supervisor Sri Naresh Kumar in misappropriation of government stores.
That's all. Yes.
Lordship, we have filed our affidavit, and in our affidavit, in para 6, we have mentioned here in that the statement made in paragraph 2 of the writ petition are not correct. The answering respondent back to state that the petitioner is involved in misappropriation of government stores worth rupees 1,84,907, manipulating official records and misusing his official position, for which the petitioner has been charged sheeted for major penalty proceeding under Rule 14 of CCS Rules 1965 by the competent authority by so and so. The petitioner has, however, without participating in the proceedings and waiting for the decision of competent authority, sought the legal remedy by approaching this honorable court through this writ petition. The action of the petitioner in approaching this honorable court without completion of the disciplinary proceeding and waiting for the decision of the competent authority is absolutely premature, and thus the present petition is liable to be dismissed on the ground alone, as the petitioner has not given any reasonable opportunity to the respondent authorities to hear his case, examine the relevant records in detail and decide the case on merit. It is further submitted that the disciplinary proceeding initiated against the petitioner held up pursuant to the interim order dated 27/2015 passed by this honorable court on the writ petition filed by the petitioner. So, Lordship, disciplinary proceeding has not even yet started, and before that, they have approached this
That's
honorable.
what they're saying. There can't be any disciplinary proceeding. Because the whole basis is Roshan Kumar has manipulated the record. But
Yes.
Roshan Kumar has been exonerated. There is no independent allegation against the petitioner. It is connected with the activities of Roshan Kumar. That's the case. So if Roshan Kumar is given a clean sheet, and where is the finding that the petitioner is responsible for movement of SK oil? There is no deficiency in the store, nothing is there. Who is the disciplinary authority?
Lordship, the CE project. Chief Engineer Project.
That is as per the rules. Which rules?
Lordship, it's annexed, Lordship, here at page 51, Lordship.
51.
51 and 52. This is type, and 53 to 56 is the original, Lordship. Lordship will find it at page 52, the type version, 0.4. Or page 54, the original version, point number 4.
Yes. Anything else? All right, then take your seat. You're Mr.
D. Bora, Lordship.
D. Bora. You're in this case?
Lordship for Mr. M.K. Chaudhary. His name is there, or P. Bharadwaj, Lordship.
All right. Mr. D. Bora, Learned Counsel. Appearing on this in this case in place of Mr. M.K. Chaudhary, Learned Counsel for the petitioner, has argued the matter with the permission of this court. First up, Miss your name?
B. Devi, Lordship.
D. Devi, Learned Counsel, is present on behalf of the
Mr. S.P. Chaudhary, Lordship.
on behalf of Mr. S.P. Chaudhary, Learned CGC, appearing in this matter. First up, by filing this writ petition, the petitioner has assailed the legality and validity of the order dated 19/9/2014 issued by the Director General of Border Roads, that is Respond number 2, imposing the penalty of rupees 1,84,907 upon the petitioner on the ground of alleged misappropriation of government stores based on a report of the Court of Inquiry convened for the purpose. Thereby calling upon the writ petitioner to deposit the said sum of money with the departmental authorities. First up, the writ petitioner has also assailed the memorandum
Dated 14/1/2015.
dated 14/1/2015, containing the article of charges served upon him with a proposal to initiate a departmental proceeding against the petitioner on the grounds stated therein. First up, the primary case of the writ petitioner is that the allegation of misappropriation of government store is based on manipulation of record, facilitating such irregular activities by one
Roshan Kumar.
Roshan Kumar, who was posted as manipulation and tampering of official records by GS number 188295 capital W store supervisor Roshan Kumar. However, in a separate court of inquiry held against Roshan Kumar, the allegations have been found to be baseless in as much as the authority have come to a conclusion that
It was an error of omission and not error of commission.
it was an error of omission within court, omission, and not an error of commission, C, within courts. Stop. The writ petitioner who was serving as, what was he serving as? Senior store
Supervisor
senior store supervisor
of 94 RCC
of 94 RCC
GREF within bracket.
GRPF
GREF.
GREF at the relevant point of time, that is during the period from 8 August 2011 to 1st December 2011. Did not have any role to play in any kind of misappropriation leading to shortage of government store, nor is there any finding of fact recorded against him to that extent. Notwithstanding the same, the respondents have not only passed an order of recovery of an amount of rupees 1,84,000, but is also proposing to hold a disciplinary proceeding against the petitioner under Rule 14 of the CCS bracket CCA bracket close rules 1965 on the same allegation, thus causing serious prejudice to the interest of the writ petitioner. First up, in support of the case projected in the writ petition, Mr. Bora has argued that the entire proceeding of court of inquiry leading to the issuance of the order dated
19/9/2014
19/9/2014 is based on a process which is completely flawed, FLAWED, in as much as the provisions of the relevant rules have been given a go by in this matter. First up, Mr. Bora submits that during the procedure of court of inquiry, his client has not been granted proper opportunity to make his defense.
Lordship, we are not allowed to cross-examine, Lordship. Moreover,
by cross-examining the witnesses.
Lordship, moreover, one senior officer was present, which was influencing the proceedings. It was
Moreover,
also pointed out.
Due to presence of senior officers during the court of inquiry, the proceeding itself was heavily influenced against the petitioner, much to the detriment of his interest. First up, it is also the submission of Mr. Bora that although as per the relevant rules, the CE project the commander, no, the CE means chief engineer.
Chief engineer.
Chief engineer, bracket project, is the disciplinary authority in this case. Yet the order of penalty has been issued by the Director General of Border Roads, bracket DGBR, who is the appellate authority. Not only that, even the appeal preferred by the petitioner against the order dated 19/9/2014 was rejected by the DGBR by exercising appellate jurisdiction, although the original order of penalty was also issued by the.
The appeal was not considered, Lordship.
Then you write like this. He submits that since the original order of penalty dated 19/9/2014 was issued by the respondent number 2, bracket DGBR, hence the appeal preferred by the petitioner before the appellate authority, which is the DGBR, that is respondent number 2, was not considered, thus causing serious prejudice to the interest of the petitioner. By referring to the materials available on record, Mr. Bora submits that since the fundamental basis of the court of inquiry was that due to the manipulation of record by Roshan Kumar and the irregularities by Roshan Kumar, there was loss of government store for which the petitioner was held responsible. After the exoneration of Roshan Kumar from such allegation, there is no basis for the authorities either to recover any amount from the petitioner or to proceed against him on the basis of the memorandum of charge dated
14/1/2015.
14/1/2015. Ms. So-and-so, learned counsel appearing for the respondents, on the other hand, has referred to the counter affidavit filed by the respondents to argue that the departmental proceeding is still pending and no finding of fact has been recorded therein till today. First up, it was incumbent upon the writ petitioner to first participate in the departmental proceeding and put forward his case before approaching this court. Full stop. However, instead of doing so, the petitioner has straightaway filed this writ petition so as to preclude the departmental proceeding. She submits that the writ petition is premature and is liable to be dismissed by this court on such count alone. Full stop. That's all. Anything else you want to argue? Anything else?
No, Lordship.
I have considered the submissions made at the bar and have gone through the materials available on record. Full stop. The basic facts of this court, of this case, are not in dispute. It is not in dispute that on 2/1/2012, a court of inquiry was convened so as to investigate into the following allegations brought against the petitioner as contained in the term of reference of the COI. At page number 23, Pavo. Double tick to double tick. First up. On 02/02/2012, the terms of reference of the COI was amended so as to include the following item in para 2. Page 24, double tick to double tick. First of- During the course of the court of inquiry, several deficiencies were noticed in the procedure adopted by the authorities, as a result of which the chief engineer had himself written letter dated 17/5/2012 with a request to rectify the deficiencies in the proceedings. First of, the deficiencies pointed out by the chief engineer includes an observation that the court has not corroborated the sale of ration stores to civilian with deficiency in ration store stock. There is no basis of figures of misappropriation on ration store stock. Further, the statement of Roshanlal had not been recorded, although fingers were also pointed towards him. That apart, Naresh Kumar Upadhyay, that is the petitioner, had not been asked about the deficiency of stores. Full stop. Thereafter, certain enquiries were made with the petitioner pursuant whereto the court of inquiry had submitted its report finding the petitioner liable. However, according to Mr. Bora, the copy of the report of court of inquiry was never made available to the petitioner. Notwithstanding the same, on 19/9/2014, the following order was passed by the respondent number 2. In page 49, double tick to double tick. Stop. Next para. As mentioned above, although the respondent number 2 was not the disciplinary authority, but only the appellate authority in this case, yet, for reasons not discernible from the materials on record, the respondent number 2 himself had passed the order of penalty without, however, referring to any specific finding in the inquiry, in the court of inquiry, as regards involvement of the petitioner in misappropriation of government store. First of all. Thereafter, on 14/1/2015, a memorandum of charge was served upon the petitioner with the following article of charges. With the article of charges and statement of imputation. To page 62 double tick to page 63 double tick. Full stop. Next paragraph. Mr. Bora has invited the attention of this court to the findings and opinions of the court of inquiry conducted so as to look into the allegation brought against store supervisor Roshan Kumar. Full stop. The relevant observations made in the report as available in paragraph 3 and 4 of the communication dated 4/11/2019 issued by the commander is paragraphs 3, 4, and 5 is reproduced herein below for ready reference to page 129 of our affidavit in opposition. Page 129 to page 130. एकदम last to the page. Very Maharaj says. From a reading of the communication dated 4/11/2019, it is thus apparent that the store supervisor, namely Roshan Kumar, has been exonerated of the allegation of manipulation and tampering of records. Full stop. There is nothing to show that there was actually any deficiency of stored items detected by the authorities, nor is there anything to show physical movement of stored items outside the depot, wherein the writ petitioner had some involvement. Full stop. As a matter of fact, the CE himself had raised question as regards the manner in which the court of inquiry was being conducted in the matter. Full stop. If there is no material or finding recorded, if there is no finding of fact recorded on the basis of forgery materials to show that the petitioner was involved in his individual capacity in misappropriation of government store, and since Roshan Kumar was found to be innocent in the matter, it is not understood as to how an order of recovery of an amount of rupees 1,84,000 something would be issued against the writ petitioner, that too without giving him any opportunity of showing cause in the matter. So, moreover, since the foundation of the departmental proceeding is that the writ petitioner was guilty of misappropriation of government store, in view of the observations made in the foregoing paragraph, this court is the opinion that such a proceeding was not maintainable in the eye of law, having regard to the facts and circumstances.
I apologize, Lordship. Lordship, the petitioner was given a questionnaire. We replied, but our evidence was not considered. We were given the chance, but our evidence was not considered.
Chance in what?
Lordship, in the second court of inquiry, one questionnaire was served
No, I
upon
have
us.
not written anything on that.
Lordship.
It is also the specific plea of the petitioner that although the petitioner had submitted his version in the second court of inquiry conducted after rectification of the defects, his evidence was not considered by the authorities before recording any finding. If that be so, there can be no doubt about the case, about the fact that this is a case where the court of inquiry itself was conducted in violation of procedural safeguard available to the petitioner, thus leading to an order of penalty for recovery of a sum of rupees so and so, without there being any basis for arriving at such a conclusion. Under the circumstances, the impugned order dated 19/9/2014, in the opinion of this court, is not sustainable in the eyes of law. Consequently, the memorandum of charge dated 14/1/2015 is also held to be untenable in the facts and circumstances of the case. For the reasons stated here and above, the so-and-so is hereby set aside. The order dated so-and-so is hereby set aside. The memorandum of charge dated 14/1/2015 is also quashed. Having regard to the peculiar facts and circumstances of the case, this court is of the opinion that there is no justifiable ground for the authorities to extend a differential treatment to the writ petitioner in this case, while ignoring the role of, if Naresh Kumar, the store supervisor Naresh Kumar, has been found to be innocent, writ petition is accordingly allowed, there will be no order as to cost.
Very much obliged.
पाठक तो आगे ही होगा।
Part budget for hearing item 15 and 16.
Yes, Mr. Chutia, have you seen the record?
There is no hearing taken place. There is no such order. Only notice were issued to them because how it is irregularities committed by them. Their relatives, their wife, their brothers, in their name, my lord, land has been irregularly, my lord, given to the KP Patta. Annual Patta, procedure is different thing, my lord, and convert to annual Patta to PP Patta is different things. And there is no, my lord, I don't think that they respond to the notice. They reply, some replies there, my lord. Whether they are date fixed for hearing or not, I don't know, my lord. The record does not say like that.
So this order is not appealable under the Assam.
Appealable. That's why, my lord, I want to submit this point, my lord. Appeal will 147. 147 is appealable, my lord. The order against the deputy commissioner, they will have to go to the board, and against the orders, ADC or circle officer, whatever may be, to the deputy commissioner. Appeal is there, my lord. Appeal provision is there. Lordship, that's why, my lord, I am submitting before Lordship. Your irregularity is large in the deed, my lord, because this person, my lord, working in the deputy commissioner's office, and they are doing this, my lord, job and getting their patta land irregularly, my lord. It is, I am more of a, my lord,
So please show her that notice was issued.
notice
Prefer
was issued.
appeal before the Board of
Yes,
Review.
yes, yes. Notice was issued. So it's just জলদি reply দিচ্ছি। Notice বসে reply দিচ্ছি আপনি। এই রুটো না দিচ্ছি। Notice দিলাম। দিলাম। ওই ক্লিয়ার। সব এগুলো। বিপিন সুইকে গ্রহণ হইছে রুটো না থেকে হ্যাঁ
এই মানুহবোৰৰ নম্বৰ
তেওঁৰ নামটো তেওঁতো ঢুকালে তেওঁ নোটিচ ক'ৰ পৰা যাব এইটো 11 চনত পঠাইছে ন তেওঁ পুতেকলৈ পঠাইছে ন এইটো অৰুণ শইকীয়া যে পিটিশ্যনৰ ব্ৰাদাৰ
ৰিচিভ কৰা
ৰিচিপ্টটো আছে নোটিচ পাইছে ৰিপ্লাই দিছে নহয় ৰিপ্লাই দিছে ৰিপ্লাইটো চোৱাই লাগিব অৰুণ শইকীয়া ৰিপ্লাই দিছে অৰুণ শইকীয়া যে ব্ৰাদাৰ অফ দিছ পিটিশ্যনৰ কেটেকিছ চন বৰুণ শইকীয়া এণ্ড দিছ ওৱান. No, they have submitted reply that we did not do this like that, my lord. Only this notice for a reply. And that's why, my lord, they did not think about the hearing of this matter.
Notice is there, lordship, in the name of the sons of the lordship, original partner, lordship. But whether they participated in the proceeding, lordship, that is not reflected in the order, if you know.
So the petitioner, there are two writ petitions.
Yes,
is it?
lordship.
So both the writ petitions, they are brothers.
No, separate person.
One is a
Two separate
petitioner's.
plot of land and separate.
But the similar case.
Yes, lordship.
Similar, my lord, same plot. Tag number, pattern number is same.
So we'll ask them to file a representation to
Yes.
hear their case and recall the order.
If necessary, they will give a hearing, my lord. Because, my lord, this irregularities is large, my lord. It cannot be done. And, my lord, moreover, government have losing their revenue also. Within 3 kilometers of areas, they cannot convert it.
All right, you take down in item number.
One aspect I'd like to point out, there is a power station, my lord, is
Oh, yes.
catering to the needs of the general people, my lord. That aspect
That's of
we
the
can-
people.
Otherwise, we have no say here, because the government has given.
No,
us-
no, they will be heard, that's all, and whatever
Even-
appropriate order,
Yes.
you will also be heard.
Yeah, he can also participate.
We have.
That land has now been allotted to.
Yes, well, it's APDCL is running a power distribution grid out there, my lord. There's a power station. running.
Yes, the
All right.
petition, by
So
at present,
if their land has been illegally taken away, they will be entitled to compensation.
My-
Otherwise, they'll, if they had no right over the land, then they'll get nothing.
my-
so far my instructions was that they are not in a position one. They are not in a possession.
Yes, that is correct. Lord. Possession already taken over.
The possession before cancellation and after cancellation. Before cancellation, they were not possessed. The land. এখন দিব লাগিব নেকি? Appeal করছো। এই 147 appeal.
First you take down here in this WPC number 874 of 2011. The writ petitioner herein is the legal heir of late Keteki Saikia, who died on 29/5/2010, leaving behind the petitioner as her sole surviving legal heir. Full stop. The case of the petitioner, briefly stated, is to the effect that the additional deputy commissioner revenue Golaghat had issued a letter dated 5/6/2001 to the circle officer, Golaghat Revenue Circle, forwarding an annual patta standing in the name of the mother of the petitioner, covering a plot of land measuring 2 kathas 19 lessers, covered by dag number 110/463 and 111/464 of Golampatti Gaon, Mokhua Moja in the district of Golaghat. According to the petitioner, the said annual patta was subsequently converted to periodic patta number 71 of Golampatti Gaon, and since then the petitioner, through her deceased mother, had been enjoying possession and ownership over the aforesaid plot of land. Full stop. Subsequently, in the month of December 2012, the petitioner came to know that the additional deputy commissioner Golaghat, by order dated 9/1/2012, had allotted the said plot of land measuring 2 bighas 1 kathas 17 lessers, covered by tag numbers 109,110,111 for setting up a 33/11 kV substation of the Golaghat Electrical Division of Assam Power Distribution Corporation Limited, APDCL, without issuing any notice to the petitioner. First up, being aggrieved by the order dated 9/1/2012, the petitioner has approached this court by filing the instant writ petition. Full stop. The stand of the revenue authorities, as projected through Mr. T.C. Chutia, learned additional senior government advocate, appearing on behalf of the respondent numbers 1, 2, and 3, is that the plot of land in question was fraudulently converted into a periodic patta land in the name of the petitioner's mother without following the due procedure of law. As such, no right was created in favor of late Ketaki Sekya over the plot of land in question. Mr. Chutia has, however, submitted that notice was issued to the petitioner, but it is not clear from the records as to whether he was heard in the matter. Mr. D. Gogoi, learned Turning Council APDCL, submits that pursuant to the allotment of the land in favor of the APDCL way back in the year December 2012. What has been set up?
Power distribution center, madam.
Power
Sub-center.
distribution
Sub-center, madam.
subcenter has been
ASC.
set up over the plot of land, wherefrom distribution of power for the benefit of the public is taking place at present. As such, there is no scope for the petitioners to get back the possession of the land. Full stop. Taking note of the arguments made by the petitioners' counsel that the land was taken away without due compliance of the principles of natural justice, this court had called for the departmental records to verify the same, said assertion. After going through the records, it transpires that notice was issued to the petitioner, but whether such notice was served upon him or not, and as to whether any opportunity of hearing was given to the petitioner is not clear from the
But reply is received against the notice. They
departmental
submitted.
record. Mr. Chutia, however, submits that the petitioner has submitted his reply in the matter. Be that as it may, since an order of this nature passed by the revenue authorities ordinarily would be appealable under Regulation 147 of the Assam Land and Revenue Regulation, 1886. This court is of the opinion that the revenue authorities must consider the objection raised by the petitioner and pass a formal order in the matter. Recorded its opinion on the claim of the writ petitioner. Therefore, without expressing any opinion on the merit of the claims and counterclaims, this writ petition is being disposed of by granting 4 weeks time to the petitioner to submit a fresh representation before the Deputy Commissioner Golaghat, ventilating his grievance in the matter. Upon receipt of such application, now, in the representation, the petitioner will not only enclose all relevant documents in support of his claim, but shall also mention whether he seeks a personal hearing in the matter or not. Upon receipt of such representation, the Deputy Commissioner Golaghat, that is the respondent number 2, may give an opportunity of being heard to all the interested parties and thereafter pass a fresh order in the matter. The aforesaid exercise be carried out within a period of as expeditiously as is possible,
2 months, madam.
but preferably within a period of 3 months from
3
the
months.
date of receipt of a representation to be submitted by the writ petitioner in terms of the order of this court. Writ petition is accordingly disposed of, the records be returned back. And in the other matter, the same.
Same,
Only
Same
the
order.
number, Lordship, and the measurement of land is different, otherwise everything is.
Otherwise, everything is same. There also it is mother.
No, only
No.
one petition.
Huh?
Only a
One
petition.
petition.
No,
No,
land was allotted in the name of mother.
no, no.
Then,
In
Okay,
Kukum Soikia
this
case.
petitioner, in the name of this petitioner.
and
1977.
you are appearing for respond number 1.
Biju Soikian, only one person.
So can you just mold this order in the other matter?
In synopsis, that is mentioned, Lordship, the measurement of land and diagram.
Same, otherwise same. Operative part. You are for Miss G. Hazarika's. So in both the cases, respond number 1, revenue, and Mr. T.C. Chitia for respond number 2 and 3.
2 and 3.
Both the cases. Mr. D. Gogoi, APDCL.
Obliged.
And in the other matter, in the beginning, you write, instead of mother, you write land was allotted in his name,
Amar Pan.
measuring so and so, covered by so and so. From the synopsis, you get. So both writ petitions disposed of,
Obliged, my lord.
send back the record.
My lord, petitioner will submit a copy of the order, my lord.
Yes, sir.
Representation along with a copy of this, certified copy of this order.
Yes. Obliged, my lord.
My lord, before my senior starts, my lord, I have 2 issues, my lord. My lord will peruse this order dated 25/5/23, my lord. There, my lord, WPTBC was included, my lord, for some views. This regards to some reservation issues, my lord. That so, my lord, since the WPTBC, the department is no more there, but I somehow, my lord, I manage through other departments, my lord, tribal affairs. I have received a communication, my lord, and their views. That has to be brought in affidavit. I have last night, my lord. Yes, there are some, my lord, delay on my part even. Last night I drafted the affidavit even, and my lord, through communication, I have sent it for vetting. In 2 days, I will get back that. I can assure, my lord. And that is number 1. And number 2, my lord, my friend P. Naik is appearing for PWD. He is on legs in another court, my lord. Just he has informed me.
That we are not concerned.
My lord.
Somebody will be on legs.
My lord,
You can be only on legs, you can't be on hands.
I apologize.
We are not concerned.
So, my lord, that part that there is a direction from this court, my lord. There is an order, my lord.
My lord.
That I want to bring on record.
Heard
My lord.
Mr. P.K. Rachori, counsel for the writ petitioner, also heard Mr. R. Dhar, Learned Standing Counsel, Department of
Tribal
Tribal
Affairs.
Affairs, bracket plain, who submits that after the bifurcation of the Department of WPP and BC, no, trifurcation, the issue raised in the writ petition comes within the domain of the Department of Tribal Affairs plain, full stop. Although he has obtained instructions from the relevant, from the concerned authorities, yet due to oversight, no the affidavit based on such instruction could not be filed. Full stop. Assuring this court that within a week from today, the affidavit will be filed on behalf of respond number, on behalf of the Department
no.
of
Respond number 5.
Tribal Affairs, bracket plains.
5, my lord.
Mr.
Respond number
Dhar,
5.
that is the respond number 5. Mr. Dhar has sought posting of this matter again after 2 weeks. Since the prayer is not opposed, same stands allowed. It is however made clear that no further time
My lord.
will be granted to the respond number 5 for filing affidavit.
Item 12 and 13.
My lord, both these writ petitions are filed by Group A officers of the Assam Rifles. The relief sought for is, my lord, cadre review, which we say that has not been carried out since 2003 when the rules for Group A officers were inducted. And not only that, my lord, the restructuring of the cadre since 1972 has not been carried out. Because here the Group A officers are, my lord, comprised of 20% Assam Rifle officers and 80% of army officers in deputation. The difficulty was that in 1970s, my lord, there were only 10 battalions of Assam Rifles. By now, it is 46 battalions. The strength has considerably increased, and therefore, my lord, the cadre structuring also had to be reviewed, my lord. So that is our primary grievance. The relief, of course, that is sought for, my lord, is only in form of a direction, because the structuring and restructuring has to be done by the appropriate authority in the competent government, including the DOPT and the ministry. So what had happened, my lord, in the earlier occasion, when we argued the matter, it appears that, my lord, the Assam Rifles has filed an affidavit, but then the ministry has not made their stand clear. Our representation that these are the grievances that we have and these are to be addressed was still pending with the ministry. And instructions, my lord, from the ministry as to what was exactly done on that, my lord, has not yet come.
I have received instruction from the ministry, my lord. So far as that senior time scale, it has already been decided.
No, no,
But
cadre review.
cadre review is pending before the concerned authority, DG Assam Rifles. They put his answer. This is pending at administration. Some time is required, my lord.
Time
It
is
is-
required for what?
To cadre review, it is to the proposal has to be submit to the ministry, madam, after preparing the proposal.
But that should come in
Whatever
form
you
of
just tell,
affidavit, my
bring it on record by filing an affidavit.
So times some time now.
How much
1
time
month,
you want?
1 month time, my lord. Yeah, administration.
Because unused vacation is coming, so essentially it will go
We'll
after.
give you,
Yeah.
we'll give you 6 weeks, but you file an affidavit. Whatever is your stand, you file it, then we'll pass an order. These matters can't remain pending.
My lord.
You have to tell us which way you are sailing.
Yes, my lord.
Then we'll see if it is okay, we'll pass an order accordingly. Heard Mr. B. Patel, Learned Counsel appearing for the writ petitioners in both these cases. Also heard Mr. A.K. Datta, Learned CGC appearing for the respondents in both the writ petition, who submits that some instructions have been received by him in response to the allegations stroke amendments made in the writ petition. However, Mr. Datta prays for some time to bring the instructions on record in the form of a short affidavit. Prayer is allowed. Hearing of these writ petitions stand adjourned for 6 weeks so as to enable the respondents to file affidavit by serving advance copy upon the petitioner's counsel. The filing affidavit will
Yes,
close
my-
the matter, that's all. There is nothing to adjudicate here.
My lord.
If you say that we'll prepare a proposal and submit it, we'll pass an order
My lord.
facilitating
Only
that.
thing is that our grievances should be considered.
That's all. That's all he wants.
My lord.
Or you can get a written instruction also.
Yes, my lord.
Deeply obliged.
Item 14.
Wait, Vijay.
Yes.
One of the petitioner before lordships is a senior ACS officer. Is aspiring for nomination to IAS. Now, what has happened, my lord, while he was serving as a chief executive officer of Dorong Jilla Parishad, he was taken into custody by police in connection with a criminal case. Now, there was an order of deemed suspension on 12/10/2017. Subsequently, he was enlarged on bail. In any case, my lord, the police, following investigation, submitted a charge sheet. Now, thereafter, a trial followed, my lord. And in the judge, the trial criminal court gave him a clear acquittal, my lord. Now, what had happened on the same set of charges, a disciplinary proceeding has also been initiated. Now, lordship knows, otherwise there is no bar for simultaneous proceeding, but only exception being if both are grounded on the same set of facts, then normally it is said that criminal case should be allowed to proceed, and subject to outcome of the criminal case, decision should be taken. Now, my lord, I'll have to satisfy your lordships that
So the
both-
criminal case is already
Yes,
ended.
ended in my favor. I have been reinstated in service. I'm working. Now, because of the pendency of the proceedings, my lord, my case for IAS is not being considered. Now, my submission is, if your lordship would kindly come to the charge sheet in the criminal case at page 39 to show the similarity of both.
No, Mr. Chaudhary, I've understood. The
Yes.
question is, if the criminal proceeding and the departmental proceeding are on the same set of facts,
Yes.
then what is prohibited is parallel proceeding.
No, my lord. No, my lord. In Jem Tang, lordship would recollect, in Jem Tang, what had happened? There was a disciplinary proceeding on the same set of charges. He was punished. He went to High Court, even to the level of High Court, his writ petitions were dismissed. In the meantime, my lord, he got an acquittal from the criminal court. Based on that, my lord, he was given all benefit. Now the question is, no, my lord, the disciplinary proceedings should not proceed. But it is also said that it should not, be proceeded further also. Paul Anthony is there, my lord. Then Kusheshwar.
So, what you are saying is, if
Yes.
it is the same set of facts,
Yes.
either criminal or disciplinary.
Yes. Yes, both cannot.
Where is that law?
Yes, yes. Now, if your lordship would kindly have 1988 4 SCC 319.
1988. Yes.
Please come to para 7 and 8. The view expressed in the three cases of this court seems to support the proposition that while there could be no legal bar for simultaneous proceedings being taken, yet there may be cases where it would be appropriate to defer disciplinary proceedings awaiting disposal of the criminal case. In the later class of cases, it would be open to the delinquent employee to seek such an order of stay or injunction from the court, wherein the facts and circumstances of a particular case, there should or should not be a simultaneity of the proceeding would then receive judicial consideration and court will decide in a given circumstances of a particular case as to whether disciplinary proceedings should be interdicted pending the criminal trial. As I have already stated, it is neither possible nor advisable to evolve a hard and fast straitjacket formula valid for all cases of general application without regard to the particularities of the individual situation. For the disposal of the present case, we do not think it is necessary to say anything more, particularly when we do not intend to lay down any general guideline. In the instant case, criminal action of the disciplinary proceedings are grounded upon the same set of facts, where of the view that disciplinary proceedings should have been stayed and the High Court was not right in interfering with the trial court's order of injunction, which have been affirmed in appeal. Well, this is the first decision when this particular view was taken that normally disciplinary proceedings should be stayed. What has fallen from your lordships. Now, my lord will kindly come to the next decision, 1999 3 SCC 679, Paul Anthony.
It is there. Yes. Yes.
1999 3 SCC 679.
Which para?
Para 22.
Para 20.
2. The conclusions which are deducible from the various decisions of this court referred to above are departmental proceedings and proceedings in a criminal case can proceed simultaneously, and there is no bar in either being conducted simultaneously, though separately. If departmental proceeding and criminal cases are based on identical or similar set of facts, and the charge in the criminal case against the delinquent employee is of a grave nature, which involve complicated questions of law and fact, it would be desirable to stay the departmental proceeding till conclusion of the criminal case. Whether nature of the charge in the criminal case is grave and whether complicated question of fact and law are involved in that case will depend upon the nature of the offense, nature of the case loss against the employee on the basis of evidence, materials collected against him during investigation, or as reflected in the charge sheet. The factors mentioned in 2 and 3 above cannot be considered in isolation to state his departmental proceeding, but due regard has to be given to the fact that departmental proceeding cannot be unduly delayed. If the criminal case does not proceed or its disposal is being unduly delayed, departmental proceeding, even if they are stayed on account of pendency of criminal case, can be resumed and proceeded with as to conclude them at an early date. So if the employee is found to be not guilty, his honor may be vindicated, and in case he is found guilty, administration may get rid of him at the earliest. So this is the line, Milord. So that if the employee is found not guilty, his honor may be vindicated, and in case he is found guilty, administration may get rid of him at the earliest. This is how the law evolved. Then eventually, Milord, 2006, 5 SCC 446.
Who is appearing for the department here?
Lordship, department, trial and affair, personal department, I'll be appearing, Lordship, but trial and affairs, Mr. Adhar, you will be appearing. So I have already
He will
sent
be,
a
but
message,
when will
Lordship.
he be appearing? That's the question.
I already have sent a message, Lordship.
Will be is fine, but when will be?
Tribal affairs is not required, my lord.
Why tribal?
At some point of time, it's not required. A personal department is good enough.
No, what has happened to the departmental proceeding?
No, what had happened in the departmental proceeding, my lord? From the affidavit, we come to know there is a report. That report was never given to me. Now, all of a sudden, my lord, the appointing authority, disciplinary authority takes a decision, they will make further inquiry. What is going on, my lord? My only anxiety is, my lord, I'm running out of time before my nomination to the IS.
What is the deadline? By what time you need to be cleared?
Logically, 2 minutes time, right?
No, we will certainly look into it, because a person cannot be deprived like this, but
it's a case of
be a case of
incarceration.
washing of department proceeding, but you can't keep it hanging to deny something to someone. So, and then there is
No, my lord, kindly have a look at this judgment. This is a totally different dimension, my lord. Now, please come to para 30 of the judgment.
Yes.
The judgment relied on by the learned counsel appearing for the respondents are distinguishable on facts and on law.
Para 30 of which judgment?
Oh, my lord, this JM Tang, 2006 5 SCC 446. 2006 5 SCC 446.
Yes. Yes.
The judgment relied on by the learned counsel appearing for the respondents are distinguishable on facts and on law. In this case, the departmental proceeding and criminal case are based on identical, similar set of facts, and charge in the departmental case against the appellant and charge before the criminal court are one and the same. It is true in the nature of charge it is true that the nature of charge in a departmental proceeding and a criminal case is grave. The charge of the case launched against the appellant on the basis of evidence and material collected against him during inquiry and investigation, and as reflected in the charge sheet, factors mentioned are one and the same. In other words, charge, evidence, witness, and circumstances are one and the same. In the present case, criminal and departmental proceedings have already noticed or noticed or granted on the same set of facts, namely raid conducted at the appellant's residence, recovery of articles there from similar charge here. In our case, investigating officer, V.B. Raval and other departmental witnesses were the only witnesses examined by the inquiry officer who by relying upon their statement came to the conclusion the charges were established against the appellant. The same witnesses were examined in the criminal case, and criminal court on examination came to the conclusion that prosecution has not proved the guilt alleged against the appellant beyond any reasonable doubt and acquitted the appellant by judicial pronouncement with the finding that charge has not been proved. It is also to be noticed that judicial pronouncement was made after regular trial and on hot contest. Under these circumstances, it would be unjust, unfair, and rather oppressive to allow findings recorded in the disciplinary proceedings to stand. In our
No,
opinion,
that's the recording of the findings of the disciplinary
no,
procedure.
my lord.
But anyway, Mr. Chaudhary,
Yes.
just forget that other part. The question is, if a report of inquiry proceeding has been prepared and furnished,
No, it has
thereafter
not-
they
it-
cannot.
It has not been furnished to me, my lord.
Where is the record of the inquiry?
Lordship, record has not been called for. If your lordship call, I can produce it.
You
lordship.
produce it tomorrow.
Tomorrow, lordship.
Produce it. Or Monday you produce.
Monday will be better, lordship.
Yes, produce the record, entire
Lordship.
record,
Lordship.
Monday. We'll see.
Okay.
Because if the inquiry report is there,
Yes,
then you can't further, means that's not permissible.
Lordship.
Unless the parameters are
Possibly,
met.
my lord, the inquiry report, no, my lord, the submission which I am making is not in all cases. Where the same set of evidence, same people are witnesses like here, my lord.
So that's right. The
Yes.
judgment you are relying upon,
Yes,
at best to the understanding of this court, at best can wash the departmental proceeding.
yes.
But it has to be on the same fact.
Yes, same witness, same
But
facts.
here they already the inquiry report is there.
No, my lord, here department inquiry was over.
That's what I'm saying.
Ah,
So now either they have to, let us see what they have done
anyway,
on Monday.
Lordship.
in this case, my lord, in fact, before when the criminal court gave the verdict, I was already punished departmentally. Against that, I went to High Court. At the same time, they went to High Court, Gujarat High Court dismissed their case. Then Supreme Court says it will be unjust,
So we'll look
unfair
into it.
and oppressive.
But certainly you can't deny someone.
Because it is
Possession.
based on the same fact, same witness.
We'll examine it.
Exactly same facts
Not
here.
Mr. K. N. Chaudhary, and senior counsel listed by Mr. D.J. Das, learned counsel for the lead petitioners. Also heard Ms. M. Bhattacharjee, learned additional senior government advocate Assam appearing for the official respondent numbers
1 and 2, lordship.
1 and 2. After hearing the preliminary arguments of Mr. Chaudhary, this court is of the opinion that perusal of the departmental records, including the inquiry report submitted in this case, would be necessary for proceeding further with the matter. As such, Ms. Bhattacharjee to produce the departmental record on 16/9/2024, registered to list this matter again on 16/9/2024 as a fixed item.
Supplementary list, item 17.
Lordship is directed to produce the original records, Lordship. We have the
Original-
records with
You have the record, but who's for the petitioner? Petitioner is not present.
Lordship.
This is the last item. Oh, then we'll have to adjourn it. None appears for the writ petitioner when the matter is called up for hearing before this court. Miss
M. Burman on behalf of Mrs. A. Gayan.
Ms. M. Burman, learned counsel appearing on behalf of Mrs. A. Gayan, learned CEC submits that the records as called for by this court have been received. However, since the petitioner's counsel is absent when the matter is called up, hearing of this case cannot take place today. Registry to therefore list the matter again after the ensuing puja vacation.
Lordship may fix a date.
After 2 weeks, after 2
Lordship.
weeks
Bless Lordship.
for hearing.